welcome to Legally Speaking with me, Tarun Nangia. Does a single day go past by you when you have not read of any high-profile accused being arrested in a PMLA matter, which is otherwise known as a Prevention of Money Laundering Act? There are many arrests happening these days, and they happen in all states of India. But because of that, the issue of liberty also comes up in news more often than not, because bail is denied. Many times questions are asked where mechanical detention of a person is necessary to investigate this crime. And that is why the issue of twin condition for bail under PMLA is also important, why bail is being denied. And that is the issue that we are going to explore today. The rulings of the courts made most recently, I think the Supreme Court also, I think in the month of December 2021, spoke on this issue. We'll explore all of that. I have a very eminent panel with me. I've got with me Senior Advocate Pramod Dubey, who joins us. He argues a lot of these cases. I have with me Advocate Abhimanyu Bhandari, who's doing a lot of these matters, not only in Delhi, but also in Chhattisgarh. Recently, you've done quite a few matters on PMLA that we got to read about in the papers. I have with me Advocate Vaibhav Ghaggar, who joins me. He also takes a keen interest in PMLA matters. And to lay the ground, may I request Senior Advocate Pramod Dubey to explain to us why bail is getting difficult in PMLA cases and the rulings of the court recently with regard to bail in these matters. Could you decode this whole thing for us, lay the ground so that we can start the discussion?
Thank you, Tarun. And first of all, I would like to congratulate Mr. Bhandari, as he's recently appointed the Additional Advocate General Chhattisgarh in Supreme Court of India. Congratulations to Mr. Bhandari.
Thank you. Thank you so much.
Now come to the point of the bail and the twin condition. Tarun, the basic problem we are facing, especially the defense counsel and the special judges of the PMLA Act, they are facing these days. There is a complete confused state of the affair these days, I would say. Tarun, first Justice Rohington passed the order in Nikesh Tarachand. And Nikesh Tarachand, there was a clear finding of the Honorable Supreme Court that the twin condition of Section 45 of the PMLA Act is unconstitutional. This is the one aspect, that is the applicability of twin condition of the PMLA Act. The second aspect was also touched by Justice Rohington in the Nikesh Tarachand itself regarding the applicability of Section 45 in anticipatory bail. And there was a clear finding of the Honorable Supreme Court in Nikesh Tarachand that unless and until a person is arrested under Section 19 of the PMLA Act, Section 45 of the PMLA Act is not applicable. Since anticipatory bail, there is no question of the arrest of the person. It is only the anticipation of the being arrested. Therefore, Section 45 is not applicable. Twin condition is not applicable. This is the one aspect. After Nikesh Tarachand, there was an amendment in 2018. But one thing is very important here. In amendment 2018, there was no amendment of the twin condition. And it could not have been done because law is settled once the act and the portion of the act is declared unconstitutional. It cannot be revived by way of the amendment subsequently. Like, let us take an example. Suppose the person has died and is declared dead. So you cannot revive that person by giving some medicine or anything. So you cannot amend the twin condition. Having said so, there are so many confusion. Then the lot of petition, especially petition, got filed in the Supreme Court, and the matter is still under consideration by the 3 judges bench of the Honorable Supreme Court of India. In between, a matter came before the Supreme Court of India in Siddharth versus State of UP. And I had the occasion to appear before the Supreme Court where Justice Sanjay Kishan Kaur passed certain direction, and it was basically emphasized, as Justice Sanjay Kishan called, basically protected the personal liberty of the individual by saying that if the person is not arrested during the course of the investigation, you cannot arrest the person under Section 170 CRPC merely to produce present the charge sheet before the competent court of law. Thereafter, there is some development. The Satinder Kumar Antel came, and the Satinder Kumar Antel, there was a guidelines, and the guidelines were passed by Justice Call. And after the guidelines, there was some intervention and the review application was filed. And on 16 December 2021, Justice Sanjay Kishan Kaul's bench clearly, unambiguously mentioned, while clarifying the earlier order in Satinder Kumar until that Section 45 has been declared unconstitutional. And so far as the amendment is concerned, that is pending adjudication consideration before another bench. And not only that, Justice Sanjay Kishan Kaul further mentioned that the categorization of the bail guidelines was only to encourage the bail, not to discourage the bail. And the court should not take it otherwise. But unfortunately, we are coming across these days, the public prosecutors and the officials of the enforcement directorate, they are taking different view before the different courts. And they are opposing the bail on the premises that this Section 45 is amended under 2018 and amendment has revived the twin condition. However, the twin condition has not been revived and there is no mention in the amendment. Recently, there is a judgment of the Supreme Court where the VC Mohan judgment, and on 4th January 2022, a bench led by Justice Khanwilkar passed the order where the High Court has granted the anticipatory bail under Prevention of Money Laundering Act. That order was challenged before the Supreme Court, and the Supreme Court, Justice Khanwilkar's bench, remanded back the matter to the High Court with the observation the High Court has not considered Section 45 of the PMLA Act. Here, we have to say something, because once there is a declaration of twin condition as unconstitutional by the Court of Justice Rington in Nikesh Tarachand, this is one aspect. The second aspect, the coordinate bench of Justice Sanjay Kishan Kaul has mentioned categorically in Satinder Kumar Antel and clarified that twin condition is already being quashed and declared unconstitutional, and the amendment is pending adjudication consideration by the another bench. I think this order of Satinder Kumar Antel was not brought in the notice of Justice Khanwilkar, and because there is no mention of Satinder Kumar Antel's judgment passed by Justice Sanjay Kishan Kaul, so that's on this aspect, this matter was remanded. However, there is one judgment of Punjab Haryana High Court, that's the divisional bench High Court led by Justice Surya Kant, Dilip Singh Man. In that matter also, Punjab Haryana High Court divisional bench passed the order that unless and until the person will be arrested under Section 19 of the PMLA Act, twin condition of Section 45 is not applicable. Thereafter, there is Arun Kumar Sharma's judgment of the Punjab and Chandigarh High Court. The same view was taken by the divisional bench of Punjab and Haryana High Court. Arun Kumar Sharma orders were challenged before the Supreme Court by the Enforcement Directorate, and the SLP got dismissed. So we have the judgment where the Supreme Court in Arun Kumar Sharma has taken the view by dismissing the Arun Kumar SLP filed by the Enforcement Directorate. Yes, Section 45 is not applicable, anticipatory bail. So my view,
point well taken. Your view is that there is no question of Section 45 being applicable from here on. It is quashed once and for all.
Not at all. It is not applicable. It's my view.
I'll take this to Mr. Abhimanyu Bhandari. Recently, I read in the papers about this case involving a bureaucrat called Babulal Gaur in Chhattisgarh, where the court also held that the twin condition is not applicable. Since you had appeared, could you share what happened in the court in that matter?
Sure.
You appear to Mr. Gore for that.
Tarun, as the learned senior Mr. Dubey rightly mentioned, that there's a lot of confusion whether twin conditions apply or don't apply. But before I get on to that judgment, I must tell you that really there should not be any confusion whatsoever. Nikesh Tara Chand, I think, is a landmark judgment which very well and puts it that the time for putting conditions like the twin conditions, and in the twin, really, there are not the two conditions, but one condition which was really awful. And that was where the court had to kind of come to a conclusion when someone is asking for bail that there are no reasonable grounds that the person has not committed an offense. In a way, you're asking the court, before you're putting someone on bail, that court, you please record your satisfaction that this person has not committed the offense. Now, a threshold as high as that for a court to cross on a bail hearing is shocking, because then might as well the court should consider quashing the ECIR or the charge sheet, and granting the person bail. So I think Nikesh Tara Chand has to be read in a holistic manner. Nikesh Tara Chand is a judgment of Supreme Court which says that twin condition is a kind of a condition which says you have to satisfy the court, and the court has to be satisfied that there are reasonable grounds to believing that the person has not committed the offense. Means you're actually turning the presumption of innocence on its head. And this is something our criminal jurisprudence will not allow. So I think you have to look at it from that perspective. Now, what the ED is arguing is that, look, when Nikesh Tara Chand was examining the PMLA Act, it said that if a person is accused of an offense in Part A of the Act, which related to other IPC offenses, that has been now amended to say if a person is accused of the PMLA offense. So this minor change which they bring into the Act means that particular condition stands revived, and the court had struck down an older version of the Act which had this little bit of a problem. I don't think so that's the way to read Nikesh Tara Chand. If you read Nikesh Tara Chand from first page to the last page, the court cites landmark decisions of UK court, of American courts to show that bail is a right and conditions like this cannot be imposed. So therefore, there is no way that the twin conditions have been revived. Now, this has been upheld by various courts, by various judgments of Punjab and Haryana court, as Mr. Dubey rightly points out. Also, the Delhi High Court in 2 or 3 judgments has said that the twin conditions are not revived. The matter that I argued before the Chhattisgarh High Court, again, the proposition was whether the twin conditions have been revived. And the court came to a categorical conclusion that the twin conditions are not revived, and Nikesh Tara Chand is good law. And that matter was then again taken up to the Supreme Court, and Supreme Court dismissed the SLP. Of course, dismissal of a mere SLP, as we all know, is not that the Supreme Court has kind of granted leave and has affirmed the contents of the judgment. It just means that the Supreme Court doesn't want to hear it, hear that matter. So really that's neither here nor there. I think where the confusion has arisen, as Mr. Dubey says, is the judgment of Supreme Court in VC Mohan's case. Now, if you look at VC Mohan's case, that also doesn't, according to me, create any confusion whatsoever. What VC Mohan's case says is that the mandate of Section 45 kicks in. It does not say that the twin conditions get revived. Now, Section 45 has various clauses and subclauses. Twin condition is just a part of Section 45. So to say and read VC Mohan as saying that twin conditions are revived, I think it's stretching it a bit too far. The court nowhere says Nikesh Tara Chand is bad law. The court nowhere says that, the trial court now has to be satisfied that the person has not committed the offense before granting him bail. Please remember, Section 45 not only puts twin conditions, it also says that if it is a woman or if it is a child, then you should consider bail more leniently. It says that if the offense is less than 1 crore rupees, then bail has to be granted. It also says that bail should not be granted till the prosecutor has been heard, which is nothing wrong in it, really. Prosecutor should be heard before bail is granted. So really, all that Supreme Court says in VC Mohan is that a Section 45 mandate kicks in. Now, there, of course, we as defense lawyers may have some misgivings on it, but be as that may, it doesn't say that the twin conditions revive. So I don't think so there is any confusion. And 2 orders by trial courts, by sessions court, which have come. One, I think, very well argued by Mr. Dubey, who's here with us today. His case where the court held and interpreted VC Mohan very carefully and came to the conclusion and granted the accused bail without applying the twin conditions. And second is another order, which I just saw, I think came yesterday in Jatinder Pal Singh's case, another order of Sessions Court of Delhi, where court has clearly said that the twin conditions, of course, have not been revived. And the court reads VC Mohan and says that VC Mohan doesn't say this, that the twin conditions are revived. So I don't think so the twin conditions have revived. Twin conditions are is an extremely draconian provision. And it is time we kind of, adopt Nikesh Tarachand with full vigor, because I think it's a landmark decision. And really, one should read Justice Bhambani's opinion on this in a matter, which I think is one of the best bail orders I have read. Unfortunately, it is pending in Supreme Court right now. I don't know whether it has been stayed or not, but I know it is pending in Supreme Court still. But, so really the clamor, which is there, the judicial clamor all over the country is whether it is Chhattisgarh High Court in this Babulal Agarwal's case, where they said twin conditions don't apply, whether it is Punjab and Haryana High Court, or whether it is Delhi High Court and the Sessions Court of Delhi saying twin conditions don't apply. I think the judicial clamor is that twin conditions do not apply. So I think, I hope that the Supreme Court in a batch of matters is considering this argument. I hope that matter is heard soon. And for once and for all, we give twin conditions a good and happy burial.
Once and for all, your Mr. Abhimanyu Bhandari says that twin conditions don't exist. They should be given a burial. The courts have in Chhattisgarh, in Delhi, as you said, Justice Bhambani said, so many others said. I'll take this issue to Mr. Vaibhav Gaggar. Mr. Gaggar, the issue of bail again crops up despite again and again courts saying that twin conditions don't apply. Does this require a reaffirmation from the Supreme Court once again so that various courts across the country get a message? Do you think that is on its way coming very soon?
So I certainly think that the Honorable Supreme Court needs to intervene in this situation because, as pointed out by both my friends here, there is unfortunately a confusion, at least in the minds of many judges and many prosecutors. The defense attorneys, to a very large extent, are convinced and on the same page that the twin conditions cannot be reimposed in this manner, cannot be brought back by a mere amendment when it has been struck off. And they have not, in fact, and I totally, I wish I had a counter view or a contra view to my friends, but I totally agree with them and ad idem with them on this issue. But the Delhi High Court, for instance, one view is Justice Bhambani's, the other view is Justice Yogesh Khanna's, where Justice Yogesh Khanna has taken a view in a matter to say that by way of amendment, they could have been reintroduced in this matter. The other views of Kerala High Court, which has taken a contra view as well. So unfortunately, there is a divergence of opinion on this. And with the ED, and just to give, do a devil's argument on this one, the ED is arguing that with the amendment, what they have brought on is to say that Section 45 twin conditions are not applicable to the offenses under the Act. A large part of Tarachand judgment of Justice Nariman went on to strike down these twin conditions, saying that everything had been pulled into Schedule A as per the 2012 amendment or 13 amendment, and therefore unequals were being treated equally. People under an IPC offense and under an NDPS offense were being brought in the same gamut. And further, that the NDPS Act by itself had this presumption of guilt. So it's to say, you had to prove in certain cases for certain quantities that you were innocent. That presumption was being brought into the Money Laundering Act. That was violative. Those conditions, in a way, were sought to be done away with this amendment. Having said that, and I agree with my friend Abhimanyu on this, the central issue is presumption of innocence. And can that be taken away by an amendment brought about in this manner? The only legislations in the country which actually allow such a presumption are things like the NDPS or terrorist, the TADA, etc. Those are acts which would allow this. So heinous crimes, it's put at that pedestal. To have a presumption at this stage to say that you're guilty of an offense under money laundering without reference to the scheduled offenses is something which I believe is really stretching it too much. And I do think that the confusion that is there currently in the judicial system, the Supreme Court would need to step in and clear the air once and for all.
Thanks for sharing. A lot of industrialists, a lot of businessmen are looking at this issue very closely. So I go to Mr. Dubey here. Mr. Dubey, as your co-panelist, Mr. Gaggar, pointed out that the Delhi High Court and the Kerala High Court had also taken a contrary view that, in a way, Section 45 has been resurrected. Am I getting that right, Mr. Gaggar?
Yes.
So if that be the case, sir, then do you think the Supreme Court needs to once again reiterate before we get a clarity on this issue?
See, Tarun, before Justice Yogesh Khanna's judgment in the Bimal Kumar Jain, I think Mr. Gaggar is talking about Mr. Bimal Kumar Jain's matter. Before that, the Delhi High Court coordinate bench has already passed the order in D. C. Kumar and S. Sai Krishna. And there is a clear finding of the Delhi High Court, twin condition is not applicable. So that order of Justice Yogesh Khanna, I would say with due respect to the order, that is the per inquirium. And the proprietary demands, you cannot, if you have any, the court has any different view, the court should have sent the matter before the larger bench, because all the judgment has passed by the coordinate bench. And one thing also I would like to mention is very important, Tarun. There is a provision, PMLA Act being the special act, and there is a provision for arrest of the accused. And that provision is Section 19 of the PMLA Act. If you see Section 19 says, if the officer has the reasonable belief that the person is guilty of committing the offense. So the arresting officer has to give the reasonable belief in the writing. Mr. X is the guilty of the committing the offense. Then you can arrest the person. What is happening these days? You are calling the accused person for the purpose of conducting the investigation, and you are arresting the accused person. When the accused is moving the bail application, your department's answer is we are in the process of the investigation and investigation at the initial stage. Now the question would be, Tarun, one side you are giving the finding, yes, he is guilty of the committing the offense. Other side you are taking the stance that we are at the initial stage of the investigation. You are contradicting yourself. So the arrest of that person is per se illegal. The moment you are taking the stand. And everywhere we are coming across the stand of the Enforcement Directorate, we are at the initial stage of the investigation. If the person is granted the bail, that would affect our ongoing investigation. This is also a major drawback in the entire scenario. Now, coming to the question in hand, I would say, and it has rightly been pointed out by Mr. Bhandari and Mr. Gaggar, twin condition is no longer exist because the amendment, there is no revival of twin condition. The bunch of the matter is there. And fortunately in Delhi court, especially the special court PMLA in Delhi, all the judges have the consistent view that the Section 45 of the PMLA, twin condition of Section 45 is not applicable. And they are taking the matters as a general bail principle, and they are following the guidelines of Justice Sanjay Kishan Kaul in Siddharth versus State of UP. But some other places, there is a lot of confusion on this aspect.
Point well taken. So what is done in Delhi High Court, it's the other high courts are necessarily not accepting it. So Mr. Bhandari, would you be of the view that Supreme Court should once and for all clarify this so that all high courts get the message that Section 45 doesn't exist, and so all bails under PMLA also are taken as general bails under IPCR? You're not audible.
Absolutely. I think not only under the PMLA Act, I think this issue also confronts us under the Companies Act, where twin conditions have been brought in on Companies Act offences. According to me, twin conditions, these conditions where you're asking the court to be satisfied that the person has not committed the offence, I think is extremely rigorous. And a condition like this should not be there in any of the statute books. But having said that, according to me, you have to look at the larger principle in Nikesh Tarachand's case, not this whether this amendment has been brought in and that amendment has, changed a few words in the book. No, not that. You have to look at the whole judgment, and you have to see that really the meaning behind Nikesh Tarachand was, the philosophy behind Nikesh Tarachand was that in today's day and age, you can't have such conditions on at least economic offenses. And therefore, anyways, under the general law of bail, there are rigorous criteria which one has to satisfy before putting one on bail, whether he will tamper with evidence, whether he will run away and not face trial. You have to have a look at the gravity of the offense committed by the accused. So anyways, the normal conditions themselves take care that it's not a thing like it's a free for all that once you get arrested, you automatically get bail. No, we already have substantial body of law which deals with this. But to say that we are going to come up and put twin conditions, I think is another matter. And I think now Supreme Court is very well clarified in P. Chidambaram's case in the Supreme Court, what those criteria should be that one should look at before granting bail in an economic offense. And the same should apply in a PMLA offense. Tarun, are you aware that, when we hear this word money laundering, we say, oh, money laundering, money laundering. Oh, it's a very big offense. It's a compoundable offense in Belgium. It's a compoundable offense in many other countries. Where did this whole Prevention of Money Laundering Act come from? It came from various treaties across the world and in Europe and Americas, which were pushing India to have this law. Do you know that the International Task Force on Money Laundering, which is behind this legislation all around the world, money laundering legislation, has themselves never recommended that there should be twin conditions in bail. One of the first countries to get what is called Proceeds of Crime Act, which is similar to the Money Laundering Act in our country, in the UK, doesn't have twin conditions on bail, has normal conditions, which it has on any other offense for bail. So I don't know why in our country, we need to have these twin conditions for PMLA. Our entire PMLA Act and the philosophy behind PMLA Act is based on all these various European treaties that our country has entered into, which deals with money laundering. None of them are telling us to have twin conditions. Then why should we have the twin conditions? Why should we even waste time debating about this? And why should we curtail people's liberties and rights? I mean, I think it is high time that everyone should read the Sessions Court order in Jatinder Pal Singh's case, where a person has spent substantial time behind bars when he should not have even been arrested. And imagine if you had put this person with the rigors of the twin conditions, he would have continued to be behind bars for no rhyme or reason. So according to me, it is high time that Supreme Court takes up this batch of matters. And it's not only the twin conditions. As your other panelists will tell you, there are more than, I think, 20 substantial questions of law in more than 100 petitions in which have been admitted by the Supreme Court, where various questions of law in relation to the PMLA Act is pending. We urgently need rulings on that because there are divergent views coming from various high courts. So yes, the need of the hour is that, this act is now being used rigorously. You are also aware. I mean, Tarun, you started the show by saying not a day goes when you don't read in the papers. So given, we had not heard of this act in 2012, 11, 13, 14. Suddenly this act has become the most contentious act. This act is being implemented. There is a huge department which is investigating. So it is extremely important that those substantial questions of law which are pending in relation to this act are once and for all decided by the court. And I'm quite sure that this matter will be taken up.
Mr. Bhandari is urging the Supreme Court to adjudicate fast and issue directions necessary so that we have some clarity as far as the issues relating to PMLA are concerned. We have about 2 minutes to go. Mr. Dubey had to say something and Mr. Gaggar can end the show immediately.
Mr. Tarun, what is the purpose of the bail? The purpose of the ultimate bail is the person should not tamper with evidence and he should appear before the court to face the trial. The bail is only the transfer of the custody. The court is transferring the custody of the accused to the surety. So still the person is the custody. So this kind of the condition should not be enforced. And this is, of course, this is a draconian law.
Point well taken, Mr. Gaggar, because you brought up that point of Delhi High Court and the Kerala judge. Can you end the show by giving a clarity after what Mr. Dubey had said to counter you?
Certainly. The Delhi High Court judgment, the previous one that Mr. Dubey pointed out, in fact, was stayed by the Supreme Court, because of which Justice Khanna was able to come out, not being bound by the issue and per incuriam. Having said that, what I would like to actually point out is something very important that Mr. Dubey pointed out. The reason to believe issue in section 19 has a lot of significance. It is not a prima facie test. Please understand, reason to believe, and there are catena of judgments on this means that there has to be credible evidence and rationale whereby the prosecution and investigation can show that there is enough of a case that the person is guilty. Now that, when read with the twin condition of 45, is inherently contradictory. And if that contradiction is there, then there is either the twin conditions cannot be made applicable or it is purely unconstitutional. One of the two provisions would be unconstitutional on the face of the record. Finally, the presumption of innocence in white-collar crimes has to exist. It is impossible for any investigating agency to come out, arrest a person, believing that someone is guilty on day one. It is just not possible even for SFI or anyone to come out with that kind of determination. And you have to protect the liberty and freedom of individuals in the country.
Thank you so much for sharing that. We'll revisit this issue in another 3 weeks or 4 weeks. I'm sure the Supreme Court is taking up these issues. There'll be some directions. Of course, we also said that what Justice Kaul said in December 2021 regarding the twin condition, that it doesn't exist. But there are a lot of clarifications now that are expected from the Supreme Court. Let us wait for that. And we take this up issue next month. We all know that the prosecutions under PMLA have gone up multiple times in the past 2-3 years. That is why this law is into focus. A lot of big businessmen are involved. And also the stake of business is involved, because businesses do get affected when there are investigations. So, but that's it for now. I'd like to thank Senior Advocate Pramod Dubey, Advocate Abhimanyu Bhandari, Advocate Gaggar to spare their time and join us for this episode of Legally Speaking. Thank you so much, viewers, for joining in.
Thank you, Tarun. Thank you so much.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.